Good afternoon, everybody. I'd like to thank you for joining Intentis FCPA group. Today we'll be talking about FCP regulations and what impact they have on GCC companies. Today we'll go over a few items. For example, just a brief overview of what the FCPA is, a little bit of history and why it was implemented. We'll touch on a few case studies, some current investigations, and trends that we can expect to see in 2013, the rest of 2013 and 2014. We'll talk a little bit about individual liability, the role that whistleblowers play in initiating investigations. We'll talk about some of the misconceptions that a lot of GCC companies and executives have about FCPA and compliance programs in general. We'll talk about the UN Convention Against Corruption, other relevant anti-corruption legislation that's been passed recently. I'd like to touch just a little on compliance programs, a path forward, what companies can do and need to start doing. Followed up by a brief acknowledgement of the Intentis team and questions with Mr. Basim Ramadan. To start off with, most people are familiar with FCPA. It's been in the news enough, but just for those who aren't, let me just briefly explain what it is. It's a U.S. law that was passed in 1977, and it was passed by the U.S. government when they became concerned that American companies, which are held to stricter standards of regulation and reporting, were operating at a disadvantage compared to foreign companies who could routinely pay bribes, and in some countries were even permitted to deduct the cost of bribes as a business expense. The law was enacted to level the playing field between U.S. companies and other companies doing business outside of the United States. So that needs to be understood. This law is specifically for illegal, illicit behavior that occurs outside of the United States. Companies that pay bribes to foreign officials are subject to criminal and civil enforcement actions resulting in large fines, suspensions, disgorgement, and exclusion from certain federal procurement contracting. And their employers and officers are subject possibly to prison sentences. To avoid such consequences, companies are implementing detailed compliance programs intended to prevent and detect any improper payments to employees or their agents. So the question is, how does a U.S. law apply to companies outside of the United States? Well, the U.S. found hooks of jurisdiction. Let me just make it clear that the enforcement bodies are the Department of Justice and the SEC, Securities Exchange Committee, commission. So they have a wide venue, or a bigger net, you could say. Companies that are listed on the U.S. Stock Exchange are subject to FCPA regulations. Companies with contracts in U.S. dollars. Companies with transactions through U.S. banks. Companies or individuals that utilize internet communication on U.S. servers. Remember, that falls under the SEC jurisdiction. Companies with agents, subsidiary shareholders, affiliates, or offices, representatives, joint ventures in the United States. FCPA also applies when doing business with employees of state-owned companies, a lot like Aramco, or even partially state-owned companies. FCPA applies when agents or distributors a distributor of a company bribes a government official on the company's behalf. The FCPA has two provisions. There are anti-bribery provisions, which is enforced by the U.S. Department of Justice, DOJ, or the accounting provisions, which is enforced by the Securities and Exchange Commission. Since it was enacted in 1977, it wasn't really enforced too much. It started becoming more active in 2006, and there are a lot of cases involved, but I don't want to go that far back. I'll just talk a little bit about 2011, 2012, some of the most notable cases. I'm sure you recognize many of these companies here. The Magyar Telekom, Hungarian company, 3 top executives were settled civil and criminal charges for $95 million. Aon Corporation had to settle SEC charges for the Department of Justice. These were criminal fines. And Siemens executives, there were 8 former executives were charged for their involvement in the company's scheme to retain $1 billion government contract, to produce national identity cards for Argentine citizens. So that was so far to date, that is the largest FCPA fine, is $800 million. The most recent you may have heard of that was in the GCC area was Tyco. Tyco also had charges back in 2006, and the charges against them in 2012 were for bribing the government officials, which were actually executives in state-owned oil companies. In Saudi and the UAE, there was like 12 different companies they were charged with. In this instance, in the 2012 case, they only had a $26 million fine. It would have been a lot more, except since their first case in 2006, Tyco had been undergoing the process of putting in a compliance program, and in consideration of that and their efforts trying to become a more compliant company, this time the charges are less. Otherwise, it would have been more than 26 million. It could have been in the hundreds of millions. This is a 91 companies on this list. At the end of 2012, there were 140 open investigations. 91 of them were for companies. The rest of them were for individuals. And if you look here, you can see a lot of the companies that you may recognize. Some of them have recently been in the news. For example, we'll go down. We can start with Alcoa. I'll discuss more on their case a little bit later. They were charged with over $300 million in criminal fines. Their CEO and their representative who brokered the deal between them and a company called Alba were both extradited to the UK and went to jail. AstraZeneca is one. A lot of these companies, you'll see pharmaceutical companies. Eli Lilly is back in there again. GlaxoSmithKline has been in the news a lot lately in China. So you can see companies in all different industries, all different areas of the world, all under investigation and all under the jurisdiction of the U.S. FCPA clauses. So far, the top 10 cases, as I mentioned earlier, was Siemens was the largest settlement at $800 million. Followed by KBR and Halliburton. BAE. Total was this year. They settled criminal charges for $398 million. The company that I talked about earlier, Alcoa, they are an aluminum company. It's a U.S. company. They provide aluminum for aluminum manufacturing. It's the key element in the production of aluminum. Alba is a Bahraini company. It is a joint venture between the Bahraini government and an Australian company. There was the case charged Alcoa with bribing the CEO of Alba to sign contracts for the purchase of aluminum for an elevated amount. In that way that Alcoa would keep their contract and they would pay the bribe to the CEO of the Alba Corporation. This is a good question. Why do good farmers pay attention when the winds change direction? Farmers depend on good weather, and if it looks like it's going to be too much rain or not enough rain, they need to adjust their business plan and their planting strategies in order to protect their business. And the same can be said of any industry. Companies and executives need to pay attention to what's going on in their own industry in order to protect their own operations and weather the changes, whatever they may be. And those changes for compliance are what's in the news, what's going on, what legislation is being passed, and who's in the court and who's in the newspaper and the rest of the media. We need to pay attention to those things. For the expected trends for the rest of 2013 and 2014, at the beginning of 2013, the Department of Justice, the Criminal Division, which enforces the FCPA compliance, asked for an additional $55 million for their already existing budget. They were given that additional $55 million, and that will go towards additional investigators and forensics accountants who will be deployed in U.S. embassies worldwide, including U.S. embassies in the Middle East. The Department of Justice and the SEC have said that their focus in 2013 and 2014 will be on fraud and money laundering and FCPA regulations and compliance. In 2012, just as I mentioned before, you have to keep this in mind, there were 140 open FCPA investigations, including GCC companies. But as you saw on the list earlier, only 91 of them were for companies. The remaining are for individuals. You can find the article about this. It's listed in the New York Law Journal on April. It was published April 8th, 2013. And when I talked about individuals, there's a reason for that. Individuals can also be charged with FCPA compliance violations. Let's look at Garth Peterson. Garth Peterson was a Morgan Stanley executive who was sentenced to 9 months in prison for conspiring to evade internal accounting controls that Morgan Stanley was required to maintain under U.S. Foreign Corrupt Practices anti-bribery law. Another one you can see down here was former chairman and CEO of Kellogg Brown & Foote, otherwise known as KBR, who have a lot of contracts throughout the Middle East. He was sentenced to 2.5 years in prison for bribing Nigerian officials to win $6 billion in natural gas contracts for the company and its partners. And it's important to note here that also KBR, for previous violations and corruption violations, has been on the sanctions list for the World Trade Organization and the World Bank, and they're going to remain on that list for sanctions against them until the end of this year, December 31st, 2013. A Hollywood couple, a husband and wife team, Gerald and Patricia Green. Gerald is 78, Patricia's 53. They were convicted of bribing Thai government officials, and each were sentenced to 6 months in jail and 6 months in home confinement. And they were trying to do a movie deal or some sort of screening. I'm not sure exactly. The bottom one on the right. This is an important one to look at. Italian police arrested the Fina Meccanica CEO. His name is Giuseppe Orsi, and Fina Meccanica is the parent company for Augusta Westland. They were charged with bribing Indian officials for the sale of 12 helicopters to the Indian government. And in addition to the charges in Italy, you have to remember that every country in the world has its own anti-corruption laws. So not only was he charged and arrested, and his trial started in Italy in June of this year, but that triggered another trial and investigation and trial in India. So now Augusta Westland and their executives are being tried for the same crime in 2 separate countries, and they're going to have to face the problems in both of them. Okay. It's interesting to note that Augusta Westland is the approved supplier for helicopters for most of the larger companies in the Middle East, including Saudi Arabia. Keep this in mind about individuals. Why are we talking about it? Simply put, Attorney Lanny Brewer, who was formerly the Assistant Attorney General for the Criminal Division, and he enforced FCPA compliance and legislation. To put simply, the prospect of significant prison sentences for individuals should make it clear to every corporate executive, every board member, every sales agent that we will hold you personally responsible and accountable for FCPA violations. Mark Nelson, also of the Department of Justice, has went on record, has said to really achieve the kind of deterrent effect we're shooting for, you have to prosecute individuals. If only sanctions out of the monetary and penalties and against companies, sometimes companies can interpret that as just a cost of doing business, but when people's personal liberty is at stake, it resonates in new ways. Recently, Intentis published an article. We didn't publish an article. We shared an article with our clients that the attorneys from the SEC who were enforcing FCPA regulations and litigating the cases actually went on record as saying they enjoyed prosecuting individual executives more than they did going after companies, because it was the executives who made the decision, and holding them accountable, it was more of a challenge, but they enjoyed it more. So they're actually enjoying their work going after these CEOs and CFOs and management. In 2012, there were only 3 individuals that were charged. You can see it's very, very small amount, and those were the 3 Noble executives that went for criminal penalties. And this year, as of July of this year alone, it's already gone after 12 individuals. So they said they were going to go after more individuals, and they have been. And interesting, those individuals that they went after, 4 people from Jet International. BizJet is a subsidiary of Lufthansa. Peter Dubois and Neil Uhl were both sentenced to 8 months in prison and 5 years probation. Peter Dubois got a $160,000 fine, and Neil Uhl got a $10,000 fine. Mr. Jensen, Jal Jensen, and Bernard Kowalski are both currently wanted by U.S. Marshals, so they're currently fugitives from the law, wanted for this. Frederick Sillens was arrested for obstructing an FCPA investigation for allegedly offering to bribe the widow of a former Guinean president $1 million to destroy evidence against his company that they had engaged in illicit behavior and activity. The widow, instead of accepting the bribe, she cooperated with the FBI and secretly recorded the meetings and several phone calls. Now, this is important to remember. She cooperated. She may have been in trouble herself, and she turned around, and to protect herself, she cooperated. So you have to look around and wonder how many of your colleagues would turn evidence in against you if their own personal freedom was on the line. The 3 other Alstom executives, David Rothschild and Frederick Perucci and William Pompani. David Rothschild cooperated with the police, or with the FBI, and his file was sealed and kept secret until the other 2 defendants were arrested and sentenced. So he cooperated and turned state's evidence against them, his former colleagues. And that brings that to the question that if your employees or your colleagues were in trouble themselves, do you think that they would turn over state's evidence or give evidence against you if they wanted to protect themselves? And that question is, and I think most people would. You don't want to get arrested. You don't want to put your family through that sort of situation. So if you had the choice between cooperating or getting a bigger fine, a bigger prison sentence yourself, of course most people would cooperate. What about your employees who aren't under investigation, who aren't being investigated for doing something illegal and aren't facing charges themselves? What if somebody went to one of your employees and offered them a lot of money to report the bribes that your company paid or received? Okay, do you think they would do it? And this is an important thing to note, because this is where another law, U.S. law, comes in. It's called the Dodd-Frank Act, and it was passed in 2010, and it was for the SEC, and it includes whistleblower protection. Well, in May, the SEC voted to adopt those rules, the whistleblower protection, to FCPA violations. So now, if anybody wants to report an FCPA violation, they can do it anonymously. There are actually attorneys who advertise, law firms who advertise on the internet to represent people who want to make FCPA reports. They can remain anonymous up until the time they get their payment. And there are certain conditions. The incentive for whistleblowers is huge. I mean, 10 to 30%, depending on the strength and the amount of the information. The information has to be original information, and it has to result in a criminal fine or penalty of $1 million or more. And then they get either anywhere from 10 to 30% of that fine. They can, like I said, they can remain anonymous, and there's no requirement for them to have reported the incident inside the company first. They could just bypass any of the company and come straight to the Department of Justice and reported it. And retaliating against whistleblowers is a criminal offense. So even if a company finds out who it is that who had reported against them or turned them in or blew the whistle, retaliating against them is a criminal offense. Now take the situation with Total. Total earlier this year settled for $398 million. That means, and one can only presume that it was a whistleblower because they were charged with bribing Iranian officials to get control of certain natural gas fields in Iran for some contracts there. You can presume that there's no strong relationship between the U.S. and Iran, so it wasn't Iran that turned them in. Somebody blew the whistle on them, and whoever that was made at least $39 million payday. Let's briefly talk about some misconceptions. One of the misconceptions that we have about the Middle East is that we don't have FCPA risks. Our company's in the GCC. We're in the Middle East. That's a U.S. law. They can't touch us. Well, not so. Any connection to a global market means exposure to potential violations of FCPA. Many small and medium companies have joint ventures, not only, maybe only in 2 countries, but they require FCPA compliance. This is especially true for family-owned businesses who are the representatives, sole representatives, or have joint ventures or franchises for U.S. companies. If a lot of family-owned business, they represent companies like Microsoft or Siemens or other companies that are publicly traded companies. You also have the regulation requirements. Companies believe, a lot of companies think that, oh, well, we're not traded on the New York Stock Exchange. We're a private company, so FCPA doesn't apply. Well, keep in mind that it's not just publicly traded companies. If you have contracts in U.S. dollars technically belong to the United States government. It is their treasury. It is their money. You own the value of the money, but the U.S. dollars actually belongs to the U.S. government. If you are having communications through the U.S. internet servers, let me give you one example. A Norwegian oil company was in the process of discussing an illicit bribe, a bribe from another company, and they went out of their company email to discuss it, and they went on to their personal email, which, you know, think about it, all of the personal email servers, Yahoo, Google, Gmail, MSN, Hotmail, these are all on U.S. servers. They discussed it there, and the bribe went through a U.S. bank. The transfer of the money went through a U.S. bank. So the companies weren't charged with bribery, they were charged with money laundering, and they were charged with conspiracy to commit an illegal act. So there's a lot of hooks in there, and since the Department of Justice and the SEC are working together, it's not just, you know, publicly traded companies that are at risk. A lot of companies believe that our employees already know our position on our ethics. It's in our policy. Well, how many times have your employees been shown the policy? How many times do your employees read the policy on a daily basis? The existence of a policy or code of conduct is good, but it's not enough to change behavior, and that's what law enforcement agencies are looking for. They're looking to see that companies and executives have done their most to change the behavior of their employees and create a compliant culture. And that has to resonate in all forms of the communication. You know, routine emails being sent, reminders, media, company briefings, meeting rooms, talking points brought up in the communication meetings, routine, regular, consistent training for employees and key individuals, key personnel, including posters, awareness things. You know, a lot of people, they do this for loss prevention and safety. They have safety awareness, and they bring out, you know, how to lift things, fire protection, where to stand, what to do in case of an emergency. But compliance issues need to be brought up in the same way so that while your company also is a safe environment, you're also a compliant environment. So in the same way that companies address safety and loss prevention, they need to do that with compliance, ethics, and compliance. Another misconception is that employees and our agents certify that they don't pay bribes, and so that's enough. A signature from your employees or your agents or your business relations, it's good, it's best practice, but it's not sufficient measures to prevent bribery. It's just like a little check in the box. They want, law enforcement agencies and government officials want to see that you've done what you can to prevent bribery, not just covered your butt with a signature. Obtaining a signature is only one of a series of actions. It's not enough. I've heard, I asked one of our clients when they were going to complete the implementation of their compliance program, and he said, when we need it. And this just baffled me. Compliance, and he said, well, compliance programs are expensive, and they interfere with business because we get lawyers involved and everything. This is a misconception. First of all, if you're concerned about the cost of a compliance program, then you really can't afford to not have one, because the cost of an investigation, a cost of charges, far, far, far outweigh the cost of the compliance program itself. It runs the same logic as a fire protection system. You have sprinklers, you have smoke alarms, you have the fire extinguishers put all over the, posted, placed in strategic places. You have axes, you have water hoses, and the reason you do this is to protect your assets. It costs money to put them in, and a good system costs a little more than a crappy ones. But at the end of the day, fires are going to happen. But if your system is good, you're putting out small fires and not replacing your entire company. You're not paying out settlements to employees who have been injured in a fire. You're not replacing your entire stock in your warehouse because the fire wasn't stopped and put out in time. It's the same idea with the compliance program. It is risk and management and loss prevention. Keeping your fires small, keeping your instances or problems small and contained internally in the company to save face, to save money, to keep you out of the courtroom, keep you out of the media, and it helps your company. Our program is affected because violations have not been reported on our hotline. I love this. I have had discussions where executives have told me that they have a hotline and it's wonderful, but it's good. Their company's in good shape. Nobody ever reports on it. Well, a quiet hotline is not always a good sign. In your company, there are other indications if you have a problem. Are you having a high turnover for employees? Do you have a lot of problems with the complaints? You have labor relations. You can tell, by office gossip and the demeanor of your employees in general, if this is a great place to work or not. Do you have no vacancies because your employees don't leave? Do you have an abundance of applications because people have heard your company is so wonderful they want to apply there? What is your average employee turnover? Has it gone up or down significantly in the last year? If you have these problems and you still have a quiet hotline, then you have more problems than you think. If reporters, sometimes people don't use the hotline because they don't trust anything will be done, and this is a disaster. If you implement a hotline, and sometimes this happens when you initially implement your compliance program, you have the hotline, people have some reports, and they're not answered properly. They're not answered and responded to in a timely manner. The investigation was not handled properly. The response wasn't done adequately. People will talk. Your employees will talk. Your management will talk. Everybody talks. Nobody's quiet in your company. You may not talk openly about it, but they will talk. And if they lose faith in your compliance program, you might as well not have it there. You've shot yourself in the foot. Sometimes employees will not call or not report because they fear retaliation. And this means maybe your no retaliation policy hasn't been communicated strong enough. Maybe you don't have one that's been communicated. Maybe they fear that if they make a report or a call, it's going to be traced back to them. That means that you haven't implemented the program or your hotline in a way that they can feel safe. A good, effective hotline has to have a way, it has to be a mechanism where people feel safe and secure to go ahead and report. These employees are your eyes and ears. They're going to keep your problems internal in the company if they can report it. If they can't, then these problems will fester, they'll grow, and then pretty soon it boils up out of the company and you end up in a courtroom somewhere. Sometimes employees don't feel loyalty to the company to report illicit behavior. If this is the case, then you're in a lot of hot water, because it is exactly that kind of environment where white-collar crime just festers. People feel okay about taking money from the company because the company hasn't been loyal to them. They don't feel any loyalty. They don't feel they're doing anything wrong. They're the good guys. They're the ones that have been stepped on. The company's the bad guy in this case. And if that's the outlook that a lot of your employees, especially your management, feels, if they feel loyalty to your company, then those are the ones that are the higher risk to put your company in danger for fraud, embezzlement, bribery. And that's what, managers people in middle management are 4 times as likely to commit or to cost the company money for corruption activity than regular employees, and executives are 16 times more likely to cause damage than to the company. The U.S. cannot enforce FCP here. I have heard this repeatedly, and I've had a very hard time sometimes explaining to some executives here in the Middle East. They can, and they certainly do. Tyco, the activity that Tyco was charged with was bribing state-owned oil companies. More than one. There were several companies they were charged with, and they were doing business here. And the U.S. was able to enforce it and enforce sanctions or penalties on them. Total was charged with bribery in Iran. So if there's any place that should be out of reach for the United States, it would be a company like Iran, when they have no diplomatic relationships between them two. But still, they were able to enforce. It is a false sense of security that they couldn't. FCPA regulation is specifically for foreign illicit behavior, illegal acts of corruption that take place outside of the United States. And I'm sure if you talk to any of the companies or individuals who have been charged, they would all tell you they never imagined that they would caught. If they had thought it was a risk, if they really felt there was a risk, they probably wouldn't have engaged in that behavior. It's when you feel that there's no risk that the behavior happens, and that's when you really get caught in the net. This is also a big misconception, more so of late than before. Anti-corruption laws are not being enforced in the GCC. 5 years ago, I would agree with you. 2 years ago, I would still agree with you. Even last year, I might. This year, absolutely not. You have to pay attention to what's going on in the news and in the courtrooms, and you'll see that this is certainly not the case anymore. GCC governments are all absolutely changing the tone from the top to join global efforts towards corruption, and they're doing this for a number of reasons. They've recognized that corruption is a problem in the area, and they're working on it. They want to be more globally competitive. They want to attract more business into the Kingdom of Saudi Arabia, into the Middle East, and in order to do that, they understand they have to meet certain requirements. And let me show you what they've done so far. United Nations Conventions Against Corruption. And this is the blue countries represent the signature parties. And that means that not only did these countries sign the UN Convention Against Corruption, but they also enacted some law in their own country which made that UN convention part of their own law. At the end of December last year, these were the signature parties. The orange countries were countries that signed it, but they hadn't ratified it by their own law yet. And the orange one in the Middle East, so far, Oman is the only one that has not signed it. Well, in January, that changed. Saudi Arabia is now a state party by royal decree. This convention, this UN convention, is now Saudi law. And this convention talks about extradition. That means if somebody is charged, if a Saudi national is, or somebody in the Saudi Arabia is charged with corruption charges, they can be extradited to another country to face trial. It also talks about seizure of personal property and money, bank accounts. It talks about joint cooperation in investigation, the requirements of the state now. They will not only implement their own anti-corruption efforts, they will require their companies, government and private companies, to implement certain anti-corruption preventative measures. This means that companies inside Saudi Arabia are now required to have preventative measures, anti-corruption compliance programs. If they don't, it's not like the government's going to come knocking on your door and say, hey, where's your program? It's going to hit you with a lawsuit. And if those companies that do have it, when they get a lawsuit, then the charges are less. They can be dismissed. Companies who are hit with an investigation or a lawsuit or accusations of corruption, who have a compliance program, are going to get off much, much lighter, maybe completely, if they can show that they made their best effort to put in a compliance program. Those companies, private, government, public, that don't have a compliance program, if they get hit, those are the ones that are going to have their multi-million dollars worth of corruption charges. Those are the ones where executives are going to go to jail. Those are the ones that are really gonna, it's going to be embarrassing, not for the company, only for the company, but also for the families of the individuals who are going to be charged, because their names are going to be out there. That's another part of it. Publishing the findings is another requirement. Let me show you what I'm talking about. Now, I put these 3 articles just to kind of show that, yes, what I just gave you, the information I gave you, is true. The governments are really actually starting to kick up and step up to the plate as far as anti-corruption efforts. And I chose these from Saudi because in the GCC, I would say that Saudi Arabia is the most resistant to change, especially from legislative pressure from outside. They are the most resistant to change. So Saudi Arabia is changing. You see the farmer down in the bottom right. It's time to start paying attention to the weather. 2 years ago, the Saudi Arabian government established Nazaha, which is the anti-corruption body. This is the commission that is supposed to look into corruption. And everybody thought that was great, and nobody thought they were going to do anything much, but 2 years later, the anti-corruption Nazaha themselves are in court. They're brought into court because somebody has brought in accusations against them that they turned in information against 3 different companies. It was quality information, it was accurate, it was authentic, and the Nazaha never did anything about it. They were in court. They were made to, be accountable for their inaction. And if you look at the date, that was in June of this year. July, just less than 1 month later, all of a sudden, the Saudi courts are publishing rulings for the first time. Now they're really starting to kick in. All of the articles inside that UN convention are now starting to be applied. They got called into, they got in trouble for not doing their job. Now they're really going to do their job. The other article I'd like to show you is the Saudi religious police being investigated for corruption. Now, most of you know Saudi Arabia, they call it the Hayya. It is the Committee for the Promotion of Virtue and Prevention of Vice, or the religious police. This organization, you never heard anything about them except for maybe the occasional article about something happened in a mall, some confrontation with expats. You would never imagine that they themselves would be investigated for corruption. Nazaha has gone after them for fraud. And unfortunately, by the way, I'd like to note that 3 individuals in the picture are not the individuals who are named in the investigation. These poor guys were just there for a training course, and they ended up having their picture taken and put under that headline. So very unfortunate for them, but those aren't the individuals who are named in the investigation. But if Saudi Arabians' religious police can be brought under investigation for corruption, then I would think nobody is out of bounds. Nobody's going to be untouchable. One of the most recent articles that was published in August of this year, and this is an important one, is in the Saudi Gazette. And the Saudi Gazette is where they publish all changes in Saudi law. They talked about an abuse law, and the kingdom has criminalized all forms of abuse. The law is mostly focused on domestic abuse, but there are, as the Minister of Culture and Information, Dr. Abdulaziz Khoja, he points out that there are specific provisions related to abuse at the workplace. Now, remember, in Saudi, the way it works is they will pass a law, and it's not going to be clearly spelled out, this is what you need, this is what it means to you, but you have to kind of be able to read between the lines and understand what it means. So let me just translate it. When it says specific provisions related to abuse in the workplace, that translates into now employers have legal requirements related to abuse and harassment in the workplace. It is now a criminal act to sexually harass someone, and it's punishable by prison time. That means that employers are now responsible for the behavior of their employees in the workplace, and they have to do certain things. The article also says anyone who knows about any cases of abuse shall report to their supervisors. This translates into now employees must be explained to them that they are required to report, and this explanation needs to be reported in a code of conduct. That means your employee handbook or your human resource guide or your code of conduct needs to make it very clear that all employees, when they see abuse, have a requirement to report it. And employers are required to have some sort of mechanism or a reporting hotline available. Since this was published at the end of August, in Saudi you have 90 days before this law comes into effect once it's announced. So at the end of November, these things are going to be required. Employers are required to report to the Ministry of Social Affairs or the police. Now remember, they've criminalized it, and this is also a requirement in the UN conventions. Criminal behavior must be reported to the authorities, to the appropriate authorities, whether it is harassment, whether it is fraud, if it is a criminal act, you are required. International law and Saudi law and Emirati law, all of them, they all basically the same thing. There's no big changes. Criminal law must be reported to the appropriate authorities, and that's what you call a self-reporting policy. This needs to be stated out in your compliance program. The companies need to make this very clear to this employees that if you commit a criminal act while you're at work, not only are you possibly going to be terminated, we have to by law turn you over to the authorities along with any facts that we may find in the case. This is a huge benefit for employers because now you have the deterrent. This is a huge risk for employees to engage in any kind of criminal activity if they know it's criminal activity. So you have to tell them what it is, tell them what the consequences are. This raises the risk in the company of engaging in illicit behavior. This is the best thing for the company to utilize this as a very clear warning. And your policy has to be conveyed to your employees and enforced by management. Here's what happens if you don't. If you have a case of harassment in your company and you don't manage it and handle it with the anonymous reporting, or if it isn't investigated and that individual or another individual goes outside to the police and reports it, and then they come back, either the Ministry of Social Affairs or the police shows up in your company and says, we have a report that this person was harassed or this person was abused, and that they told you about it, all of a sudden the company's in trouble because you mismanaged it. And there's not going to be an excuse, well, we didn't know. Well, it was in the newspaper, you should know. They're not, ignorance of the law is not going to get you off the hook. And also companies that have their compliance program in place, that have the reporting mechanism, that have their code, these are better places to work. You're going to attract a better quality of employees and retain your good ones if you can ensure that you have a safe and secure working environment. The last one, it's not permissible. It says in the article, it's not permissible to disclose the identity of an informer in an abuse case without his or her consent. What this translates is your reporting hotline should allow for anonymous reporting. A telephone number to your general auditor, a telephone number to your labor relations is not going to protect the anonymity of the person. They are afraid, but the reason they want this to be anonymous is they want people to feel secure to report. So this is what they're going to do. Briefly, a path forward. So companies now understand that they're required to have a compliance program. It's not spelled out, you must do A, B, C, D. You look at the laws, you look at the UN convention, and you look at the abuse law, you can see and read between lines, have your convention, your compliance professionals or compliance department take a look at these and understand what the requirements are. But just briefly, all of them, both of them require a resolute tone from the top. Your management, your board, your directors, your executive management has to say, we have a compliance program, or we're going to implement a compliance program, and everybody is required to buy in and support it. And these compliance programs have to include a no retaliation policy. That means no retaliation against people who are reporting, because you want people to feel comfortable and secure to report stuff so that you can manage instances or incidences inside your company internally before they get out. Self-reporting mechanism, which means any criminal activity that happens inside your company, you make it clear to your employees and your management, we are required by law not only to investigate them, but to turn you over to the authorities. This is a deterring effect. You need this. You can use this to your advantage. It's very good. Your policy should be within the appropriate languages. It should also be, since most companies employ not only Saudi nationals, you should have all of your policies available in Arabic and English, and whatever language you have a number. If you have employees who don't speak Arabic or English, try and match the language they have. For communication and training, you should have a code of conduct and a supplier's code of conduct. These are two different instances. Some companies may not need a supplier's code of conduct, but everybody needs a code of conduct. They are two different things. They manage two different aspects. The supplier's code of conduct goes out to everybody you sign a contract with. A supplier, a vendor, a business relation, anything like that. That tells them what your ethics and compliance policy is and what you expect from them. Board and management training. Your board and your management are the ones that are going to be held accountable if something goes wrong. So they need to have their training so they know what to expect, what's expected of them, how they can be more efficient at ethics and compliance. E-learning should be available for your employees. It doesn't have to be so expensive. It can be something manageable, but they, e-learning so that they understand what your code is, what your compliance program is, what your message is, what you're required from them, and then have it either function related to their specific work and level related according to the level of authority. Monitoring is really, really vital, because a lot of companies, they'll go through the problem and the hassle of putting in the beautiful compliance program, and then they don't monitor it. They don't have they don't look at their case management. They don't provide dashboard reports to management and the board to tell them what's happening. This is what we're hearing. This is the reports that we're receiving. This is how many reports we're receiving. This is our plans for addressing these issues. These are our plans for our training. This is what we're doing. They should know what's going on. Your management and your board are the ones that are going to be held accountable if something goes on. They need to be told efficiently and effectively, clearly, given a lot of detail on what's going on. You need to have proper investigations and auditing. Every report that you have, it needs to be treated very sensitively, very confidentially, and with the understanding that every report you receive is possibly a case that could land in the courtroom, and so there has to be certain steps taken in order to proper documentation, proper warnings to protect the company from any further liabilities. Companies who mishandle investigations can end up in even worse trouble. Annual review is where you look at new legislation, any problems that you've had in the company, reports that have made, and how it applies to your program. How can you improve on what you have? Third-party due diligence. I didn't touch on this in this reporting or in this presentation. And what this is a huge part of it. You need to know, this is where you find out who you're doing business with. Before, when you're getting ready to sign a contract or going through or evaluating your bidders for a contract, you would do a financial due diligence, which means you would look at the bidder's financial background, their financial history, to find out if they have any issues with their company financially that's going to affect you and the execution of the contract. You would look at them also technically. Are they technically able to handle or manage the contract, so you would do a technical due diligence. Compliance due diligence is the new one. You're doing third-party due diligence on compliance. Who are you getting in business with? Looking at the company. Do they have any compliance violations? Do they have any issues? The company that we talked about earlier, Alcoa, they used an agent to broker the deal between them and Alba. Had they done appropriate due diligence, there would have been a lot of red flags on that particular agents, which may have decided to continue to use him, but they would have been able to take steps that would have protected the company from any liability should that agent or representative do something illegal. You need to know, you've heard that old saying, when you lie down with dogs, you get up with fleas. Well, a lot of times in business, people, companies, representatives, other agents, they come highly recommended, and you don't really know what you're dealing with, and you need to do your third-party due diligence in order to protect your company from that kind of liability. At this point, I'd like to take a moment, just a brief moment, to give my acknowledgement to the Intentis leadership team. We have Mr. Rashid Safraoui. He's our chairman and managing director. We have Dave Cook, who's our Chief Operating Officer. He's located in New York. Basim Ramadan, he's our Vice President of the Eastern United States. We have myself there, Zainab, a priest. I'm Director of the Middle East. Daniel Darty, who's our Senior Advisor to Europe and North Africa. And Marie Wilson, who's our Senior Advisor for the Western part